On behalf of the Director General, Human Resources, and the Director, Learning and Development Unit, Ministry of the Public Service and Talent Development, welcome to our webinar, From Grouses to Grievances, Pathways to Resolving Challenges. I am your moderator, Alison Bess Sullivan, Senior Human Resource Officer, Learning and Development Unit. And with me is my producer, Laura Taylor, Senior Human Resource Officer, also from the Learning and Development Unit. As I outline the rules of engagement, you are reminded to pause or minimize any distractions, focus on the presentation, and reflect on your own experiences. During the session, please use the Q&A tool at the bottom of the Zoom screen to send your questions to the presenter. At the end of the presentation, we have set aside 10 minutes for the Q&A. As we wrap up the session, we will invite you to complete our participant feedback form using the link that will be placed in the chat towards the end of the presentation. At this time, I wish to welcome and introduce your presenter, Ms. Joanne Jordan. Ms. Jordan is a strategic HR leader and educator with over 25 years of experience, dedicated to helping others reach their potential as a trained coach through Erickson Coaching International and a mentor with King's Trust International. Ms. Jordan currently serves as Deputy Director of People Resourcing and Compliance within the Ministry of the Public Service and Talent Development. Ms. Jordan, welcome.
Thank you, Alison. Thank you very much. I'm hoping that you can hear me and you can hear me clearly. So somebody is saying that she's getting feedback. But I am hoping that you can hear me clearly, and I am looking forward to this interaction with you from Grievances to Grievances. So every organization, no matter how well structured, will encounter disagreements, misunderstandings, or feelings of unfair treatment. What matters, though, is not the absence of conflict, but how fairly and transparently it is resolved, right? So I am, as Alison indicated, Joanne Jordan, and I'm a Deputy Director here at the Ministry of the Public Service and Talent Development. And the aim of this webinar is to equip public officers with a clear understanding of the formal grievance procedures established under the Public Service Act Cap 29 to ensure fair, transparent, and timely resolution of workplace grievances. So I am not sure if you are familiar with the tools at the bottom of your screen. So I'm going to ask you a simple question. How many of you believe that most grievances happen because of a misunderstanding other than malice? Yeah, how many of you believe that most grievances happen because of misunderstanding rather than malice? So use the feature at the bottom of the screen to raise your hand. Just keep your hand up. Let me see how many of you they are. All right. I have 207 attendees, so I am hoping to see some good numbers here. All right, I'm seeing those numbers clean. But in all truthfulness and in all honesty, grievances start as misunderstandings and they progress through lack of intervention in its early stages. So we are hoping that the objectives of this session will help you in making sure that these misunderstandings don't escalate. So at the end of the session, you should be able to define workplace grievances, differentiate between complaints and grievances, explain the stages of the grievance handling procedure, demonstrate proper communication and documentation when it comes to grievances. So before we get too deep into thing, we're sticking the toe in the water to begin with. Everything that we're doing here is grounded in legislation and it's grounded in the Public Service Act. So our intention this morning is to reduce some of the legalese and put it in simple language so that you understand and you can connect some of these terms with what happens in day-to-day life. So what triggers a grievance? Now, Section 12.1 of the Public Service Act, Cap 29, states that where an officer or an employee is aggrieved by any action or decision of a person appointed to the commission who has or who had supervisory powers over that person, a person other than whoever we've referenced in paragraph A, who has supervisory powers in respect to the employment of that person, or C, a fellow employee. The officer may invoke the procedure with respect to grievance handling that is set out in the fourth schedule. So you may say to yourself, well, the person in A and the person in B is the same thing. Technically, no. A is the person who has direct supervisory powers over the individual. B is someone who may be at a higher salary scale than the individual. So they may not be their direct supervisor, but by virtue of the salary scale that they sit, they are in a supervisory position, but they may not be the direct supervisor. And then C, the fellow employee, that is fairly clear cut. So we're going to continue reinforcing the correct terms and correct terminologies and as we go forward. So now that we have spoken about what triggers a grievance, the question is, what is a grievance? Section 13.3 of the Public Service Act defines a grievance as a complaint regarding the alleged violation of the provisions of any agreement with a trade union or any other body authorized to represent an officer or employee in respect of employment matters, the rules, the alleged violation of the rules or regulations or any conventions applicable to the category of workers to which that person belongs, the alleged violation of the principles of natural justice or the dignity of the human person, and any combination of the above. So they're not static, where if you have a violation of A, you can't have a violation of 4. It's not that. This definition gives you where the violation can occur. So over the next few slides, we're going to look at each point individually and provide you with some workplace examples. We're not going to be able to provide all the examples, but as we proceed, you will be able to see the nuances and be able to apply them in your sphere of control. So the first violation relates to any agreement with the trade union or any other body authorized to represent an officer. So as you know, there are ongoing negotiations and subsequent agreements between the government and trade unions. And only yesterday, it was reported in the news that there was an agreement between the Ministry of Education Transformation and the related unions of the reestablishment of the term sleeve provision for teachers. This was a 12-year grievance. Yeah, but it is an agreement with a trade union that had broken away, and that grievance was as a result of the teachers no longer receiving their term's leave. And if we look at provision number two also speaks to the advance this slide for me there, Allison. Provision number two speaks to rules or regulations as applicable to a category of officers. So it is a combination of one and two. So with the provision of the conditions of service as it relates to teachers with the terms leave, that would have been a violation of the first category, I would say. And the second violation speaks to rules and regulations that are applicable to a specific category of workers. In this case, it would have been teachers. Similarly, you would have things like hazard allowance for some categories of workers, uniform allowance for other categories of workers. So a grievance may emerge if the rules or the conventions do not apply to that particular category of worker. The third violation speaks to principles of natural justice. And these are the fundamental rules that ensure fairness, transparency, and impartiality in decision making, especially in workplaces with respect to disciplinary matters and even the grievance procedures. The principles include the right to a fair hearing, a rule against bias, that it should be evidence-based, and a reasoned decision made. So how would that look like in the workplace? A chance to prepare, present evidence, speak, and to respond, where decision makers are impartial and neutral with no conflict of interest, prejudgment, or favoritism, where it is based on facts and evidence, not assumptions, suppositions, or opinion, and where reason for the final decision is provided. And the final violation speaks to the dignity of the human person. And within your workplace environment, you should therefore be free from bullying and psychological harassment, discrimination and harassment based on personal characteristics, degrading work conditions, and personal and professional disrespect. So I want you to note that the violations within this section that the violations which constitute a grievance progress from the personal, the individual, to the general, something that affects the individual alone, to those things which may affect us all. So for the purposes of this discussion and our discussion, we're going to bring it down a little bit. A simple definition for a grievance is a formal complaint about a serious concern related to work, working conditions, treatment in the workplace, or a violation of policies, procedures, or employment rights, right? So this definition covers the major elements of the definition outlined in the Public Service Act, Cap 29. And I want to emphasize that a grievance indicates an actual breach or perceived injustice requiring a formal resolution. So if an employee comes to you with a grievance or what they consider to be a grievance, don't be dismissive, because that is what their perception is. Yeah. So who can you have a grievance against? Yeah. We have a poll on the screen for you to participate in, and you have a single choice. Who can you have a grievance against? A colleague, a supervisor, a head of department, or all of the above? Let's see how we go. So make your selection and press enter. Wait and see what the results are. I hope you're all participating.
Yes, the numbers are still climbing. So far, we have 192 persons have responded out of
Okay.
248 persons. I'm going to give you 10 seconds more.
Thank you, Laura. Right. So you can have a grievance against, and the correct response is truthfully all of the above. And out of 189, I'm going to add 3 more from the chat. So truthfully, you can have a grievance against everyone who is listed, a colleague, a supervisor, or a head of department. So thank you for participating in that brief poll, and I see that we're getting somewhere. So thank you. So which of the following counts as a formal grievance? A disagreement with a colleague, feeling unfairly treated by a supervisor, unsafe working conditions, or all of the above. And you have just about, I think it's 30 seconds, or just about, to vote. All right. I am seeing all of the above, and there are some little nuances which I am hoping that as we go through the next couple of slides, we're going to see the distinction between the disagreement being unfairly treated and the unsafe working conditions. And I am purposely not responding and correcting or giving guidance at the moment. I will respond by going through the slides and see if we feel the same way at the end. But it gives me an idea of where you are thinking. So we're now going to look at the difference between Grouses, which are complaints and grumblings, concerns, and grievances. I'm not going to go into a lot of detail at this time, but we're going to discuss it as we go through the following slides. And I want to share, I mentioned it to the team at LDU yesterday. Gross is such a good old-time Bajan word. I love to hear it. I like the fact that we're bringing these things back to the fore. So how do we distinguish between a gross and a grievance? A gross is an informal expression of dissatisfaction. It is usually resolved quickly and there's no documentation. Yeah, it's like somebody comes and says, I don't like how you spoke to me this morning, and you talk it out, and there is consensus and agreement at the end. There's no need for anything formal to be documented. A grievance, on the other hand, is a formal expression of dissatisfaction. It is usually done in writing. It requires investigation and adherence to the grievance procedures, and it requires a documented allegation of serious matters. And remember that we said earlier that it is a perceived injustice. So the person who is aggrieved perceives that some injustice has been meted out to them, and we have to approach it as though their perceptions are valid, not to be dismissive. So grosses, as we said, are usually verbal and can be addressed through discussion or minor adjustments, and they're usually resolved quickly without formal procedures. And as we said, somebody come in to say that the office temperature is too cold, that's a gross or a complaint. And grievances involve formal escalation, and an example of a grievance would be the denial of overtime pay, which is contrary to policy, or the denial of a payment of an allowance, or a denial of a particular condition of work, which is supposed to be provided. All right? So we talked about a grievance. So now what is a concern? A concern may be a formal or informal expression of a general worry or observation about issues. So it is not like a gross, which may be a one-off complaint. It's an observation of something that has been reoccurring, but it is still preventative in nature, and it may be documented for follow-up discussion. So concerns are often raised proactively during team meetings or feedback sessions, while grievances may be reactive and formalized and may usually require HR involvement. So, for example, you may be worrying about understaffing during December for the Christmas holiday, while a grievance may be an employee not being paid for hours of overtime worked or not being paid their travel allowance. So, therefore, the key difference is that a concern aims to prevent problems and a grievance addresses existing violations. So, a concern may very well be proactive, which gives management the opportunity to look at it and preempt something from turning into a grievance. Yeah. So, in recapping, a grievance is a formal process. There is nothing informal about a grievance. It is serious and ongoing, and it follows a structured procedure. Documentation is required for a grievance. An example of a grievance will be something like workplace discrimination, non-payment of allowances, changes in conditions of service. So now that we have an understanding of what triggers a grievance and the definition of a grievance and the distinction between a gross a complaint, a concern, and a grievance. And that's all on a continuum. So the gross may be on one end, the grievance at the other. And I'm loving this conversation in the chat that a gross is like they have a bone to pick. Yes. I just love the Barbadian vernacular. I love it. So when we look at the stages of the grievance handling procedure, then this is when we go back to the legislation. But before we delve into the stages, let's have a look at a scenario. And I want you to keep this in the back of your mind as we go through. Now, Anne, the administrative assistant, works in a converted basement office. The ventilation is poor. The ceiling has damp patches, indicating some sort of recurring water leak. Anne develops persistent headaches and respiratory issues, which she suspects are caused by mold or poor air quality. She mentions this to her supervisor several times, but the request to inspect the air quality or to fix the HVAC system are ignored. And then submits a formal written grievance noting the dates of previous verbal complaints to the permanent secretary through her supervisor. So write in the chat for me if you believe that Anne's gross or complaint counts as a formal grievance. Do you believe that this counts as a formal grievance? So you can put that in the chat. Yes, formal. Yes, it does. Yes, yes. All right. Oh, awesome. Yes, it does. It does count. Awesome. So yes, it does. Yes. Awesome. So we're going to launch a poll. And the question is, as an employee or as a supervisor, what worries you most about filing a grievance? Is it writing it clearly, submitting correctly, fear of backlash, or not knowing next steps? So the poll is on your screen. What worries you most about filing a grievance, either as a supervisor or as an employee? Writing it clearly, submitting correctly, fear of backlash, or not knowing the next steps. None of the above, says Stefan. That's not one of the options, Stefan. So for those who are with Stefan saying none of the above, just drop in the chat for me what it is that you think is not covered in the poll. Something that we have not considered, so that our moderator can share some of those. But what I am seeing, based on what people are putting in the chat, is that the stress of having to write it out, the stress, the fear of backlash, writing it clearly, fear of backlash. The supervisor sits on it and you're constantly redirected, matter not being addressed in a timely manner. All right, I'm seeing some things here that hopefully, well, I know we are going to address. There, I am seeing someone saying, Laura, to put the poll on the monitor. Is it up? I am seeing it. Is it that others are not seeing it?
Yes, I can see it also. It is still rolling. It's
Mm-hmm.
still available. I didn't end it.
People are responding.
Yes, I
There are
am
people saying
seeing
that they cannot see it. Okay.
so far we have 181 responses out of
Okay.
265 persons.
Okay, no
And
problem.
the numbers are going up slowly.
Okay. For those who are unable to see it, um, put your responses in the chat, please. And for those who are unable to see the chat, if you look at the bottom of the screen, you should see chat, the word chat. If you click on it, the chat window should come up to the right of your screen. All right, so some of the comments, sometimes the powers that be do not deal with issues. So backlash and victimization, I'm seeing a lot of. Yes. All right. Somebody is saying they're not seeing a soul apart from themselves in the chat. In the chat box, you should see an option that says host and participants. You should be able to see that. Laura or Allison, there's some people who are not seeing the chat, so I'm not sure if you can guide them.
Okay.
All right.
Yes,
Thank you.
that may be right. That should be rectified at this time.
Okay, thank you. So, what worries most of you about filing a grievance is one, the majority of people indicated fear of backlash, then was not knowing the steps. And there's a tie, I would say, between writing it clearly and submitting correctly. And there are some messages in the chat that speak to supervisor sitting on it, knowing or not knowing the transparency of how a decision for or against is made. Will there be a duty to state reasons in the response to the officer, etc., etc., etc.? So I can see some of the concerns that you have within the chat, and going forward with our slides, I'm hoping that I can provide some guidance and allay some of the fears, if not all. All right, so stage one of the grievance handling process. Now, the grievance handling process is the fourth schedule to the Public Service Act, CAP 29. And while the definitions of who can trigger a grievance and the definition of a grievance was outlined in the body of the Public Service Act, CAP 29, the grievance procedure is the fourth schedule, right? And that is what we're going to be focusing on. So, in the initial stage, the focus is to resolve workplace issues quickly and amicably through direct communication, where the employee and the supervisor engage in discussion. In some cases, a shop steward may be invited. Now, I know that employees feel more comfortable if they're going to a supervisor or next level manager accompanied by someone, and that is your right. Whether that person be a work colleague or the shop steward, that is your right. Yeah. The procedure states and this is the formal language that's within the fourth schedule, the aggrieved officer or employee, the shop steward of the union that represents the officer or employee, and the supervisory officer of the officer or employee may seek to resolve the grievance within 3 days after the grievance has been reported. Right? Now, the grievance procedure, as we indicate, what happens where there's no shop steward? You can take an officer that you trust. You can accompany somebody with you to that meeting. So the first initial communication requires a private meeting. It allows for definition of the issue, and it seeks to have an amicable solution. So who is involved? The employee, the immediate manager or supervisor, and the shop steward, if or friend or trusted colleague. So what this does not tell you is what triggers the grievance. And what triggers the grievance? The aggrieved officer submits in writing to the supervisor, the immediate supervisor, that there is a concern. And the supervisor should then, within 3 days of the grievance being reported, trigger that initial communication, that private meeting to get an understanding of the issue and to work through an amicable solution. Right? You must remember that at this preliminary stage, it is beneficial to take notes and create a record of the discussion and agreed on actions for clarity. And to do this, communication and documentation become best practices. So the significance of communication is crucial because it manages the emotions and ensures that the process is understood. It builds trust and confidence. It provides transparent updates to ensure the employees feel that their concerns are being taken seriously and handled with integrity. So supervisors, this is for you. Remember, we talked about not violating the laws of natural justice. So we have to ensure that the grievance is received, that the grievance is accepted, whether you agree with it or not. That is not part of this discussion at all. You do not have to agree because it is a perceived injustice on the part of the employee. So therefore, you have to ensure that as supervisor, you build trust and confidence, you manage their expectations, you clearly communicate the steps of the procedure, the expected timelines, the potential outcomes to which would prevent dissatisfaction, especially if there are delays. The significance of this communication also facilitates dialogue. Active listening and empathetic communication help the parties remain objective and focus on resolution rather than emotion. And this initial stage, one of the intentions is to prevent escalation. So open dialogue can resolve small issues informally before they turn into formal, long-lasting conflicts. So I know y'all saying, you know what? Emotion. That's right, Naya. Emotion is always the first line of defense. It always is. We are emotional beings. And when we perceive an injustice, our first response is either fight or flight. Truthfully speaking, the amygdala kicks in and we go to that reptilian brain and we're ready to fight, we're ready to argue, or we can cry, we can withdraw, we can do all these sort of things. Sometimes you need to take a beat. And for those who have gone through supervisory management training or some emotional intelligence training, or sometimes doing that self-reflection, they've always said never respond when you're angry or upset. So take a beat. If you perceive that you have been aggrieved, take a minute and then document if you have not yet done so, providing all the necessary facts. If you do not have it, then we will discuss how we can proceed from there. Does that include, this is a question, does that include asking to be excused from the meeting? You are well within your right. If you do not think that you are emotionally ready to deal with the meeting at that time, to ask to be excused from the meeting. But bear in mind that in asking to be excused from the meeting, that you put a time limit on it. Can I be excused for 5 minutes just to gather my thoughts? Can I be excused for 10 minutes? Can we reschedule this meeting until tomorrow, until I am able to gather my thoughts together? But don't leave it open-ended, and be professional. Yeah. So the employee's role then within this grievance handling process, I want to say up front, the employee has quite a bit of responsibility and quite a bit of power, if I may truly say that. With respect to the employee's role, the employee is required to report concerns and submits those details in writing. So when we look back at the scenario that I read at the beginning of this process, Anne put her concerns in writing after informally communicating her complaints. She put her grievance in writing, documenting date, times, and occurrences. The employee is responsible for reporting the issue and submitting a written statement detailing their grievance. This initiates the formal process and provides a clear record of the concern. The employee has the right to be heard and to have a fair and timely resolution process. So stage 1 should be resolved within 3 days. The employee has the responsibility to provide clear, factual information and cooperate throughout the process. Right? So that is the responsibility of the employee. But the supervisor also has a responsibility in this process. So the supervisor now, having received that written grievance, that supervisor has a role in to investigate the issue and to attempt early resolution. And they have the right to receive clear information as it relates to the grievance and support to manage the resolution efforts. Yes. And the supervisor has the responsibility to engage in good faith attempts to resolve the grievances, to ensure the confidentiality, and to document the process and provide a written outcome or decision within 3 days of receiving that grievance. The supervisor does not have the right to dismiss that grievance. The supervisor has a role in that process. All right. I'm seeing a long question in the chat, so I'm going to ask that we make a note of that for discussion a little bit later. So confidentiality is paramount during the grievance process to protect all parties. Details, including identities and sensitive information, are shared exclusively with those directly involved in the resolution on a need-to-know basis. This approach ensures a safe environment for raising concerns, free from fear of gossip. Therefore, ministries and departments must adhere to data protection laws, guaranteeing secure storage and restricted access to all grievance records. And I will dare to say it goes back to the, I'm just trying to pull it up, that first, when we looked at the definition of a grievance, it goes back to the principles of natural justice and the dignity of the human person. So if someone comes to you with a grievance, before they get out the door, there should be, wait, you hear what she said about this? But she could only be an idiot. We are not doing that. As supervisors, we have to take this very seriously and take our role very seriously. And I see that we have a comment in the chat that these things work in an ideal world, but we all know how people can be. But that's who we are. We are the people. So we have to stop it. We have to stop doing it. When it happens, we have to not encourage it. All right? So at this stage, and we're still in stage 1, mind you. We're still within this three-day period. At this stage, the supervisor should investigate and clearly document all relevant information, as this helps address underlying issues before they become lawsuits. Documentation also serves as a legal defense, as it proves the employer took steps to address the complaint. It also shows a duty of care and reinforces the ministry's or department's commitment to employees that similar grievances are treated in the same respect. So when we are looking at the documentation, the employee details and the complaint, we have the full name of the employee filing the grievance and the person or the situation the complaint is against. The nature of the complaint should be clear, simple, and factual, describing the issue or incident. It should show dates and times, specifically when the incidents occurred, where the incidents took place, names of any individuals who observed the actions in question. If there's a contract or policy violation, the specific company policies, procedures, or employment contract clauses believed to be violated. And this is triggered by the employee, and this is what the grievance should contain. You should also include supporting evidence, any relevant documents, emails, photographs, or logs that corroborate the employee's claim. Previous efforts, documentation of any steps already taken to resolve the issue informally, including dates of discussions with managers. You should also include the desired outcome or remedy, a clear statement of what the employee wants to happen to resolve the issue. For example, an apology, change in work duties, reversal of a decision. So in that initial meeting, you want to make a record of the date, time, and the attendees of that initial discussion. You want to have notes or minutes of that meeting, a summary of what was discussed, including the employee's verbal statement, the employer's response, and any disagreements. Agreed upon actions, any immediate step or interim measures agreed upon, even if the case is not yet resolved. And this is what is the responsibility of both the employee and the supervisor. The supervisor's responsibility is to call that initial meeting within, as soon as the grievance is received, have that preliminary meeting and seek to resolve the issue within 3 days of receiving that complaint. So what happens if, in the estimation of the employee who submitted the grievance, that the supervisor's response and outcome was not satisfactory? The procedure states that where there is no resolution in the matter in accordance with the first step, the aggrieved officer or employee may, in writing, appeal to the permanent secretary assigned to the ministry or department within which the office to which the aggrieved party is appointed falls, to determine the matter within 7 days of the date when the matter reaches the permanent secretary. And you realize that I'm going out of breath reading that. In other words, if you get the response in writing from your supervisor and you don't like what you get, you submit in writing to the permanent secretary of your parent ministry asking for their intervention. And the permanent secretary has 7 days with which to respond. So I want you to take your mind back to the scenario with Anne. And Anne escalated the grievance process when she submitted a formal written expression of dissatisfaction to the permanent secretary, noting the dates of previous verbal complaints to her supervisor, which went unacknowledged, unactioned, or addressed. So this is the second step in the grievance process. The written appeal must be submitted in writing to the permanent secretary. Right? So in documenting to the permanent secretary, what Anne is doing is Anne is providing a package of information which documents all that has taken place so far. So Anne is providing the essential incident facts, the exact time and date, the record when the unsafe condition was first noticed, when it was reported, including any follow-up times, the precise location, be specific, the 3rd floor bathroom middle stall, very specific, instead of saying just upstairs bathroom. A detailed description of the hazard, describe the unsafe conditions or practices. For example, the bathroom handle doesn't flush, or something along that line, that you have to take off the tank cover and lift up the thing for the toilet to flush. The parties involved, if any, names and job titles of people directly involved or exposed to the hazard. Names and contact information of colleagues who witnessed the hazard or reported incidents. So when you are then escalating to the permanent secretary, you are, in essence, behaving as though the permanent secretary knows nothing about it. So you are providing the permanent secretary with the necessary evidence in order to make an impartial decision. So when we're talking about evidence and documentation, we're looking at things like photographs and videos. Take clear photos or videos of the unsafe condition. Taking care to show the context. Timestamps on digital photos are invaluable. We want physical evidence. Keep samples, if possible, of broken equipment parts or documents that prove the hazard. You want to have previous reports or logs. Document any prior oral or written complaints you or others have made about the same issue, including names of supervisors notified and dates. You want to summarize the impact of the circumstance has on the aggrieved officer, and you want to provide evidence such as doctor's notes, etc., to support. And you indicate what action could be taken to resolve the issue. So that's why I said earlier that the employee, the aggrieved officer, has quite a bit of power in their hand. grievance, right? So in the second stage of the grievance handling process, the role of the permanent secretary is to investigate and to provide a decision within 7 days. They investigate, have an impartial approach to the matter, and their role and their responsibility is very much the same. They're required to investigate, and they're required to provide a decision within 7 days. And that the right that the permanent secretary has is to get access to all the necessary information. That is why it is important for the aggrieved officer to submit all the necessary documentation. Don't rely on a supervisor to submit it. Don't rely on an officer in the HR department to submit it. Don't rely on anybody else but you to submit to the permanent secretary. The permanent secretary's responsibility is to assess the grievance impartially, document the decisions, and communicate the outcome in writing within the stipulated timeline, which is 7 days. Yes? So in the event that you get the response from the permanent secretary as the aggrieved employee, and you are not satisfied with the outcome within that 7 days, you can escalate to the Director General Human Resources of the Ministry of the Public Service and Talent Development. And I want you to note that between stage 1 and stage 2, only 10 days have passed. 10 days, 2 weeks, 5 days a week. Yes? So stage 3 says, where the union representing the aggrieved officer or the employee is dissatisfied with the decision of the permanent secretary, the aggrieved officer or employee may so inform the Director General Human Resources in writing, and the Director General Human Resources shall determine the matter within 10 days of receipt of the matter. So if the employee is dissatisfied with the PS's decision with respect to the grievance, remember, the grievance is a perceived injustice. So if the officer feels as though they're not getting any justice, they have, according to the legislation, the right to escalate. And this step, stage 3 to the Director General Human Resources, involves a more formal review by a higher level official who examines the case impartially. So using our case example, Anne is submitting a written appeal to the Director General Human Resources. And in submitting this written appeal, Anne must submit all the documentation from stage 1 to stage 2. All the documentation. So their initial submission, the response from the supervisor, their submission to the PS, the response from the PS. Right? So the submission to the Director General Human Resources. So the Director General's role, yes, is to investigate and review the complaint or the grievance that is submitted and to provide a decision within 10 working days, which is 2 weeks. Yes? The Director General has the right to examine the case file, the testimonies, the evidence. The Director General also has the right to ask any additional questions that they may need to ask in order to get a full understanding of the case. And the Director General HR, the responsibility is to conduct the HR management audit to ensure the department follow the proper procedures And the DGHR must also ensure that the grievance handling procedures were followed as set out regarding the rights to the written formal process. And the Director General has the responsibility of providing a decision within 10 working days. Yes? So if the officer is not satisfied with the response from the Director General Human Resources, we are at the penultimate stage of the grievance handling procedure, and the employee can appeal to the head of the public service, which is the final internal authority. So we've gone from supervisor to permanent secretary of the ministry, from permanent secretary of the ministry to Director General Human Resources, and we've now gone from Director General Human Resources to the head of the public service. And the procedure states that where the aggrieved officer or employee is dissatisfied with the decision made pursuant to subparagraph C, which is Director General Human Resources, he may, within 10 days of the date when that decision was made, appeal to the head of the public service. So it has moved from the officer having a specific time in which to respond, and it has now the balance or the burden has been shifted back to the officer, that when you receive that response from the Director General Human Resources, you have 10 days to escalate it. You have 10 days in which to escalate it to the head of the public service. So if the employee is dissatisfied with the previous decision, you have 10 days to escalate to the highest internal decision maker, which is the head of the public service. So using our case example, Anne is submitting a written appeal to the head of the public service and must therefore submit all documentation from the first three stages: the initial complaint, the submission to the permanent secretary, and the response from the permanent secretary, the submission to the DGHR, and the response from the DGHR. And the employee has 10 days in which to submit that appeal to the head of the public service. Right? And the head of the public service, the final decision maker, is required to provide a decision within 10 working days as well. And the head of the public service has the right to review all the documentation and to hear appeals, to deliver a fair and final decision, to ensure organizational policies are upheld. So the head of the public service within that 10-day period will do whatever is necessary to gather any additional information that is required in order to prepare and provide an impartial decision as it relates to the grievance. Yes? So this is stage 4 of the grievance handling. So in the event that the employee is not satisfied with the response received by the head of the public service, we are now at the final stage where the union may declare a dispute. And this says, the procedure says, where the decision made by the head of the public service is not accepted, the union may declare that a dispute exists. So this is the last resort in the grievance procedure. It signifies that the internal resolution efforts have officially broken down, and the declaration of a dispute by the union indicates the formal start of external or collective dispute resolution process. When we say union, we mean the trade union or other body authorized to represent an officer or employee in respect of employment matters. Now, the union's role is to support and escalate unresolved grievances. And if you look at the processes within the grievance handling process, stage 1 and stage 2, while the shop steward may accompany the officer in stage 1, the formal inclusion of the union does not come until it is escalated up to a higher level. The union advocates on behalf of members, and the union's responsibility is to provide guidance and represent members effectively. Right? And as I mentioned in when we started this session, the grievance that the teachers union had with respect to the reestablishment of the terms leave for teachers has been 12 years in being resolved. So sometimes resolutions are not immediate, but as the representative I heard said on the news, the union supported. The union escalated where necessary. The union did not stop advocating for its employees. Yeah. So and those that they represent. So the union at this stage, at the end of stage 5, may indicate that there is a dispute, but they may not call out people to strike. They may not do those sort of things. They may engage in discussion and they may engage in negotiation. And they will continue the communication with the officers and the people that they represent to keep them up to date with what is going on with the process. All right. So as we discussed in the steps or the stages of the procedure, we've recognized the significance of communication and documentation. And that communication and documentation is at every single stage, from the employee initially trigger the grievance process, to the supervisor investigating and documenting the result, from the PS investigating and documenting result, from the DGHR investigating and documenting the outcome, and the head of the public service investigating and documenting the outcome. Communication and documentation are therefore critical in the grievance process because they provide a transparent, fair, and evidence-based framework that protects both the employee and the employer. So when we're talking about proper communication, we're talking about acknowledging receipt of that documentation promptly. HR or management supervisor should acknowledge receipt of the grievance in writing immediately or within a set time frame. During meetings, listen without interruption to the employee's concerns, ensuring they are heard. Remain neutral and objective. Approach the grievance without bias, avoiding assumptions and focusing on facts. Provide regular updates, inform the employee of progress, especially if there are delays in the investigation, ensuring transparency. Clear written outcomes, deliver the decision in writing, explaining the findings, the reasoning, and any actions taken. Explain the right to appeal. Always inform the employee of their right to appeal the decision and the process of doing so. So when we are talking about proper documentation, we're talking about submitting in writing. Even if a grievance starts informally or with a complaint, it should be formalized in writing, either via letter or email. And it should be detailing the nature of the complaint. You want to focus on the facts, not supposition or speculation. Document what happened, when, where, who was involved, avoiding emotional or exaggerated narratives. List events in chronological order, in date order, to help your reviewers understand the sequence of events. Include supporting documentation such as emails, WhatsApp messages, team communications, witness statements, or photos. You want to document everything. Keep a written record at every stage, including the initial complaint, acknowledgement, meeting minutes, investigation notes, and the final decision. And state the desired resolution. Clearly outline what outcome or resolution is sought. Now, there's a lot, and I know it's really heavy. And before you submit a grievance, you can have someone you trust review it, somebody who's impartial to review it, to be able to say to you, I don't think perhaps that you should put this in this way, in this tone, using this language. I'm a little unclear about this section. Can you clarify this for me? So sometimes, don't submit, as we always say, don't submit when your head hot. Take a beat and review perhaps multiple times before you submit. Now, there's a question in the chat. What happens if you're not a member of the union? This question was in relation to stage 5. If you're not a member of the union, you can still contact a union to and place your case and ask for their assistance in an intervention. I know of circumstances where this was successfully done. So alternative dispute resolution. Now, our legislation allows for the use of alternative dispute resolution techniques in resolving issues. And the Public Service Act at Section 12(2) indicates that an officer or employee referred to in subsection 1. And if you recall, subsection 1 speaks to, you may not recall, so I will repeat it. Those persons who can trigger a grievance, which would be an action against a person appointed by the commission who has supervisory powers, someone who has supervisory powers but is not a direct supervisor or a fellow employee. So anybody referred to in that section may, in place of the procedure outlined, seek the process of alternative dispute resolution. So the employee may opt, rather than going through the whole grievance procedure process, may opt for alternative dispute resolution, or the permanent secretary may recommend alternative dispute resolution. The DGHR or the head of the public service may recommend alternative dispute resolution as a way of resolving the grievance. And this includes conciliation, mediation, or any other method of dispute resolution. So ADR truthfully focus on resolving conflicts amicably through the help of a neutral third party rather than through litigation. And it is generally faster, cost-effective, and less adversarial than court proceedings. It encourages cooperation and communication between the parties to reach a mutually acceptable solution. It involves a conciliator who meets with the parties separately or together, and assisting them in reaching an agreement. Mediation is similar, but typically more structured, with the mediator facilitating negotiations. And such processes provide parties control over the outcome and can preserve working relationships, which is especially important in workplace-related disputes. So I want to reinforce these decisions and timelines, and I want you to notice that if you are looking at a grievance and we follow the grievance handling procedure, any grievance should be resolved within 45 days. It should be resolved within 45 days, giving space for perhaps additional information. So the preliminary resolution is within 3 days. The second stage should be a response within 7 days. And the permanent secretary will respond within 7 days of receiving your complaint, not 7 days at the beginning of the whole thing. It has to be within 7 days of them receiving it. So if you took 35 days between stage 1 and stage 2, don't say then that the PS did not respond in 7 days, because the PS has to respond within 7 days of receipt. Same thing with stage 3. The Director General Human Resources will respond within 10 days of receipt. Then the officer has 10 days to escalate to the head of the public service, and then the head of the public service has 10 days with which to respond, and thereafter the union. And don't hold me, Paula, to 45 days. I am just saying that if we follow the timelines as outlined in the legislation, and the persons follow the timelines accurately, the process could be resolved within, let's assume, 45 to 60 days. And this is working days, business days. Yes? So if you add up those days there that are on the screen, 7 and 3 is 10, and then 10 and 10 is 20, and 20 and 10 is 30, and in between there, you allow some time for the process to, allow for documentation and making sure that the package is accurate and whatever. That is what I'm talking about. So don't hold me slavishly to 45 days. Look at the timelines and recognize that within these business days, not calendar days, business days, if everything goes according to plan and there's no need to declare a dispute, that a grievance can be successfully concluded within that timeline. Right? And I want to reinforce the roles. The employee must speak up respectfully and document properly. The supervisor must listen objectively, avoid dismissive responses, and respect the timeline. The permanent secretary acts as a formal adjudicator and must respond within the timeline. The union supports but does not automatically escalate without due process. The Director General Human Resources and the head of the public service ensures fairness at the highest level. Right? I see a question, can the head of department supervisor ask for additional time during the various stages, for example, to investigate? Yes, and this is where communication, we've been saying, is so important. If as a supervisor you have received a grievance, just give us a second, Laura. Let me just answer this question. If as a supervisor you've received a grievance and you have started your investigation but you require additional time, go back to the employee, indicate that I have started the investigation, but so and so is not available for me to obtain information from, and therefore I'm going to need a little bit more time to conclude my investigation. Can I have an additional 3, and be very specific, an additional 3 days in which to conclude the investigation? If the officer says yes, then make sure you conclude within the 3 days, because that is, they're trusting you. You're building trust, right? If they say no, you document within your report that you have asked for additional time in which to conclude the investigation, and the officer responded in the negative, and as a result of that, the response is incomplete. So we have to be mindful and of the importance of communication. Yes. All right. So let's see if something stuck. So we have a first scenario. An employee feels belittled by how feedback was delivered in a team meeting. They approach the supervisor informally but felt dismissed. Is this a grievance? So Laura, please launch the poll. And those who have access to the poll, you can put your response, whether or not this is a grievance. Those who cannot see the poll, you can put your response in the chat. I'm seeing a response, some response in the chat.
Okay, just 10 seconds more.
Thank you. 9, 8, 7, 6, 5, 3, 2, 1. So the majority indicated that it is not a grievance. And that is correct. It is not a grievance. As some persons indicated in the chat, it's not a grievance, it's a gross. Technically, it's not a grievance, but it is a complaint. It is a one-off situation which may be handled internally through a discussion with the supervisor. So it's not a grievance. Yeah, it does not meet the definition of a grievance because it's a one-off situation. Let's look at our second scenario. An employee reports feeling consistently ignored in meetings by their supervisor. Is this a grievance? And again, if you're unable to see the poll, you can put it in the chat. An employee reports feeling consistently ignored in meetings by their supervisor. Is this a grievance? Ah, almost close. So the majority of people have indicated that this is a grievance. This is a very close one. It's a fine line for me. I would say that based on our earlier definition, we spoke about perceived injustice. So the officer, after continually being ignored, the officer may see this as an injustice and therefore see it as a grievance. But there is opportunity for the supervisor and the next level supervisor to de-escalate the situation. Yeah. And continued perceived violations without resolution can escalate into a grievance. So this scenario is actually at the tipping point where it straddles that line, moving from a complaint gross to a grievance. It's very close to that line. And depending on where you sit, it may be seen as a grievance, or it may be seen technically not as a grievance, but an opportunity to de-escalate before it becomes a grievance. But it is very, very close. Quasi-grievance. It is very, very close. Yes, and this is where, as supervisors, we have to be cognizant of the nuances, where and I keep referring back to the definition that speaks to perceived injustice, because you as a supervisor does not see it as one. It is not for you. It is the employee, what the employee sees, what the employee believes, what the employee perceives. And for them, perception is truth. Yeah. And let's go to the final scenario. Scenario number 3. An employee whose hours of work are 8:15 a.m. to 4:30 p.m. Mondays to Fridays have been advised that a shift system is now being implemented. As a result, they will now be required to work on weekends. Is this a grievance? And according to you, the majority said yes, it is a grievance. And 67% said yes, and 33% said no. And I want to take you back to what we said in the very beginning. A grievance, section 1213(3)(a). A grievance includes a complaint regarding the alleged violation of the rules and regulations. No, not that one. Yeah. Not that one. Not the rules and regulations. The provisions of an agreement with a trade union or any other body authorized to represent an officer or employee with respect to employment matters, and conditions of service, which is Monday to Friday, 8:30 to 4:30, is part of your conditions of service. You would have gotten a letter stating that your hours of work are Monday to Friday, 8:30 to 4:30. It made no mention of a shift system. So this scenario can trigger a grievance process. Yeah? It can trigger a grievance process. And I want to remind you that the grievance process is triggered by the employee. So in this circumstance, the employee can go the route of going to the, if you're hearing some background noise, I apologize for that, but there's a music truck going up the road. The employee would put in writing to their supervisor the reasons why the shift system will not work for them. The supervisor then has 3 days in which to respond, and it goes through that grievance process that way. Yeah. And I saw a question in the chat asking for an explanation for natural justice, and I will repeat it here, that there are the fundamental rules that ensure fairness, transparency, and impartiality in decision-making, especially in workplaces, disciplinary matters, and grievance procedures, which include the right to a fair hearing, a rule against bias. It should be evidence-based and result in a reasoned decision. Yes? So, ladies and gentlemen, it is at this stage, and you can see clearly that there are nuances depending on circumstances and situations. And as supervisors, we have that responsibility of approaching each submission of a grievance with an open and impartial mind, knowing that the person who has submitted that grievance has a perceived injustice. And open communication goes a very long way in de-escalating matters before they become serious. Yes. At this point, I want to thank you for your attention, and we are going to open for a few questions. So there were a lot of questions going into the chat, fast and furious. So Laura, if you can assist.
Yes, I can. Let me open up. There was a long one that you said to note for you. I'm going to start there.
Okay, thank you.
Would it be fair to say then that if an officer makes a verbal complaint about an officer, that it would be an escalation for that supervisor to put in writing the complaint to the head of department without discussion with parties and trying to resolve the issue? Let me drop that in the chat because it's a long one.
It's a long one. Okay, so we talked about roles and responsibilities. The supervisor has, the supervisor and everybody in each of these stages will require some measure of support. If a supervisor chooses to discuss the matter with their supervisor in order to have guidance, understanding, etc. The supervisor is free to do that. What, however, should happen is that the supervisor should communicate to the individual that that is what they're going to do. Open communication. And I'm going to give an example. I received a complaint from Laura with respect to something that I am not familiar with as the supervisor. I say to Laura, and I acknowledge receipt of her grievance. I say to Laura, I am according to the legislation, I am required to investigate what you have submitted as a grievance. And in the process of my investigation, it may require me taking this information to persons at a higher level to seek clarification and further guidance. That way, Laura knows up front that there is the possibility that the information will go outside of that circle. But the supervisor still has the responsibility to respond with an outcome within 3 days. The supervisor can't just escalate it up to the permanent secretary and not do anything. That's abdicating their role as supervisor. Yeah. So the supervisor still has some measure of responsibility there. And it goes back to open communication, letting them know what the process is, letting the officer know what steps are going to be taken, indicating to the officer when a response can be expected, and sticking to the timeline. And if they're not able to stick to the timeline, go back to the officer and indicate that more time may be required. Yes, please.
Okay. Define record of the meeting. I believe in actual video or audio recordings, which all parties should have a copy before it leaves the meeting. Is that allowed?
I would not suggest that you record either audio or video any meeting without permission being given by the persons within that meeting. So up front, do I have permission to record the meeting? The permission is either granted or it is not. If it is not granted, accept that it is not granted and proceed to take your own notes. When we talk about a recording of a meeting, we really don't mean audio and video only. You can have a written record of the proceedings as well. But I will never advocate for someone to go into a meeting and secretly record either audio or video without getting permission from the persons within the meeting that recording is being, whether they give permission for a recording in audio or visual recording to be taken.
And our final question.
Mm-hmm.
Submit to PS. Does this mean that through head of department does not apply?
through head of department is a courtesy. So you submit through head of department as a courtesy, letting the head of department know that you are escalating the matter. And I will say that while ideally the head of the department should forward or submit comments, etc., remember, going from the grievance procedure as outlined, the responsibility is at the employee to ensure that escalation happens at every step. So submitting to the PS is a courtesy, through the PS is a courtesy, and you will put in your correspondence submitted through the PS, but you also have the responsibility to follow up to make sure whether or not the PS has sent it on. And if they have not, you are all within your rights, rules of natural justice and all, submitting it directly. But as a courtesy, please submit through the PS head of department and follow up and make sure that it is done. And if it is not done, you are well within your rights to submit directly.
Thank you, Ms. Jordan, for providing that comprehensive answers to the many questions asked. Attendees, that concludes our Q&A segment. All unanswered questions will be reviewed and responses will be sent via your emails within the next 2 weeks. So don't worry if your question has not been answered at this time, they will be answered and sent to you via the email.